Seats in the front, so if any of you would like to move up front for a closer view, you're welcome to do so. We understand that there's been some accident on US 59, and that may be one of the reasons why people are delayed in getting here. So we're going to begin the program notwithstanding. My name is Marvin Nathan, and I want to welcome all of you here this afternoon. It's especially my privilege to include you here. I'm serving double duty. Ray Nimmer, the Dean of the Law Center, is ill and is not able to participate in the program this afternoon. So I'm going to try to fill in for Dean Nimmer as well as for myself. Just a couple of housekeeping matters. First of all, I want to acknowledge that the sponsors of the program today are the law firms of Bergen and Drophy, and David Berg, founding partner of Bergen and Drophy, is here. And I'd like to thank my own law firm, Nathan Summers Jacobs, for being one of the co-sponsors of the program. We've been doing this now for, I guess, 4 years, and we're very, very pleased to be able to participate with the Law Center in bringing outstanding panelists and programs to the Law Center. I am also here on behalf of the Anti-Defamation League, and I want to begin our program by giving you a little background about the ADL before I introduce our panel, which I'll do in just a few minutes. The ADL was founded in 1913, almost 100 years ago, and it may well be the pioneer American civil rights organization which was formed to secure justice and fair treatment to all, citizens alike, and end forever unjust and unfair discrimination against any sect or body of citizens. ADL has used throughout its existence the weapons of education, communication, persuasion, legislation, and litigation to fight against prejudice and bigotry. ADL has become a global voice against all forms of hatred. ADL's national director, Abe Foxman, has often said that the concentration camps of World War II did not begin with bricks, but with words, ugly, distasteful words that eventually poisoned a society and gave rise to institutionalized hatred, discrimination, bigotry, and ultimately to violence and death. We live in a country that believes in freedom of speech and freedom of press, and we therefore accept that words, no matter how ugly and how distasteful, cannot be stopped by legislation or judicial action. We know that the best antidotes available to combat hateful, bigoted speech are good speech and education. What is hate speech? Is it possible or desirable to regulate it at all? How do you explain to the press, internet providers, and other internet companies what their responsibilities are in the face of hate speech? How do you best confront hate speech? When hateful speech accompanies hateful actions, what is the best way to invoke our judicial and legislative system? Those are all questions that ADL addresses not just every week, but every day. Has the internet facilitated hate speech? The internet is a vast interactive medium based on a decentralized network of computers around the world. The internet provides easy access to anyone who wishes to provide or distribute information to a worldwide audience. It is literally used by hundreds of millions of people every day. While the beneficial effect of the internet in expanding the amount of information available to its users is self-evident, its low entry barriers have also led sometimes to unwanted and unforeseeable consequences. An example is reported in today's Houston Chronicle about an area teenager who was accused of hatching a sinister plot to kill as many little kids as possible in a shooting rampage and posting it on an online chat room. Posting of an anti-Muslim film over the internet led to violent demonstrations and protests and threats by Egypt to arrest Americans on charges of harming its national unity, insulting and publicly attacking Islam, and spreading false information. The anti-Islamic video that provoked such violence was posted on Google, and although requested by the White House to ban the video, Google determined that the film was not hate speech under its rules because the film did not specifically incite violence against Muslims, even though it mocked their faith. However, Google later decided to block the video in response to violence that resulted in the death of 4 American personnel in Libya. claiming and citing exceptional circumstances, even though Google previously had determined that the video was not hate speech. Free speech absolutists say all expression, no matter how despicable or offensive, should be allowed online. Others suggest that internet companies should be flexible enough to exercise restraint under exceptional circumstances. Banning hateful or offensive speech is virtually impossible. Facebook has some of the industry's strictest rules, and its policies prohibit content that threatens or organizes violence or praises violent organizations. Facebook also explicitly prohibits what it defines as hate speech, which is attacking a person. Like ADL, companies such as Google and Facebook are addressing these issues every day. Our program today is entitled Racists, Bigots, and the Law on the Internet. We are fortunate and privileged to have 4 panelists to lead us in a discussion about the viral spread of bigotry over the Internet and what we can do about it. It's my personal privilege to introduce them to you this afternoon. First, let me begin with my good friend, Christopher Wolf. Chris is a partner in the firm of Hogan, Lovells, and is a director of its information management practice group. Chris graduated cum laude from Bowdoin College and magna cum laude from Washington and Lee School of Law. He's the founder and chair of ADL's Cyberhate Response Task Force, and he serves as co-chair of the Inter-Parliamentary Coalition for Combating Anti-Semitism Internet Task Force. Chris is joined on his left by Jeffrey Rosen, who is a professor of law at George Washington University. Professor Rosen is a graduate of Harvard College, summa cum laude. He attended Oxford University, where he was a Marshall Scholar, and he graduated from Yale Law School. Jeff is the author of essays and commentaries that have appeared in the New York Times Magazine, the Atlantic Monthly, and the New Yorker. Jeff is a well-known First Amendment expert and is part of the International Task Force on Hate Speech, which is led by Chris. And to Jeff's left is Peter Molnar. Peter is a senior research fellow in the Central European University Center for Media and Communication Studies. He co-edited a book on hate speech that is being published this month entitled The Content and Context of Hate Speech, Rethinking Regulation and Responses. He has taught and lectured at numerous universities around the world. In 1999 and 2000, he was a Fulbright Fellow at Cardozo School of Law, at Columbia Law School, and in the spring 2000, a Fellow at the Joan Shorenstein Center on the Press, Politics, and Public Policy at Harvard University. Judson Hoffman is a graduate of the University of Michigan Law School. After graduation, Judd practiced law with several national law firms. He previously served as Assistant General Counsel of AOL, and in 2010, he accepted his current job with Facebook, where he is the Global Policy Manager for Facebook, and he leads the team that is responsible for the global rules governing the behavior of users, advertisers, and developers on the Facebook platform. Please join me now in welcoming our panel this afternoon.
Marvin, thank you very much for that great introduction, those wonderful comments, but most importantly for everything you've done for the ADL as National Civil Rights Chair and through your leadership here in Houston and nationally, and this isn't your graduation from the ADL. This is just a interim thank you for everything you've done, because you will continue to contribute greatly, I'm sure, in the years to come, and I look forward to working with you. And on behalf of the panelists, we thank everybody here at the University of Houston and the ADL for having us. This is a vitally important topic, and obviously one that is incredibly current. I was a little concerned when I saw the sign that said racist and bigots this way, but then I read underneath and it was the description of our program, so that made me a little more comfortable. I'm only going to stand here for a minute, and then I'm going to take my seat and turn to my colleagues on the panel, and we'll have a discussion. But I thought I might set the stage a little bit more than even Marvin did, and you did a great job, and I think, describing the issue, Marvin. And we've invited Marvin to interrupt and interject at any time if we're kind of veering off course or missing the obvious, or not really focusing on the fundamentals. Sometimes we get too deep in the weeds. But the way we're going to proceed is I'll set the stage a bit. Then I've asked Professor Rosen to address the United States perspective on hate speech from a legal perspective, what the First Amendment parameters are. Then Peter Molnar, who has just written this book, and I think there are flyers here so people can order the book, and if you have one, I'm sure he'd be happy to autograph it as well, is going to talk about his personal experience in Hungary as the drafter of the first Hungary post-communist media law, as a member of parliament for 8 years, and as a European who lives with the European legal structure. And then Judd is here, really not just representing Facebook, but we're going to have you be the representative of internet intermediaries, if you'll take on that mantle, because we're going to talk quite a lot, I think, about the role of intermediaries, given what we'll hear from Jeff about the license that the First Amendment gives with respect to hate speech. Marvin described the ADL's involvement in this issue, and it really dates way before my involvement, back to 1986, when the ADL published a report called Bulletin Boards of Hate. It sounds really quaint today, but it dealt with these dial-up bulletin boards where people could exchange messages, and what the ADL found as it monitored hate groups, which is something it's done for quite a long time, is that haters were adopting new technology and using it to organize and to recruit and to reinforce each other. And in less than 20 years, as the internet has developed as this amazing tool of communication and education and entertainment and automation today, it also has become a tool of haters. It was literally the case that if you were a white supremacist or a bigot or a homophobe or any other manner of hater, that in order to meet with fellow haters, you met down a dark alley or in a dank basement. And to communicate your ideas, you typically sent them through the mail in plain brown wrappers. There just wasn't this opportunity for mass communication that the internet has provided. So it's really the dark underbelly of the internet that has provided so many opportunities to so many people around the world. And what's interesting is that as this phenomenon has developed, which I'll describe in a little more detail in a moment in terms of what is the content, what is the activity of haters on the internet, most of the focus when you talk about misconduct on the internet or even illegal activity has been, appropriately enough, on child predation, has been on obscenity, has been on other legal violations, illegal music downloads, illegal video downloads. There hasn't been as much attention on this issue of hate on the internet, and one of the reasons is that in the early days of hate on the internet, and by that I mean 1995 to about 2006, we were talking about pretty blatant and sometimes nonsensical and laughable websites of hate groups that were static and served as billboards that most right-minded people just ignored. Now, believe me, there were plenty of hate groups that had websites that espoused really terrible, terrible ideas, but they didn't have the profound effect that they do today after the advent of social media, where everybody could become a publisher. Whereas before 2006, you had the organized hate groups who had webmasters. Today, everybody can be, if you will, a webmaster. They can have a Facebook page. They can post to YouTube. They can use Twitter. And they can more easily have their own website and also publish videos and music and pictures that advance ideas of Holocaust denial or white supremacy or homophobia or racism. And so no longer relegated to dark alleys and plain brown wrappers, but also no longer relegated to just the static web. They're using social media in a really robust way. And they're using it to victimize minorities and to embolden and empower, if you will, like-minded haters and to recruit followers. And in their wake, there's been an online culture that has developed, frankly. And it was written about yesterday, or Tuesday actually, in the Wall Street Journal, and you may have seen it. And in the personal journal section, why are we so rude online? I don't know if anybody saw this article, but it goes on to say that online browsing lowers self-control. And the article describes the isolation of being online. Reminds me of the New Yorker cartoon of the two dogs sitting next to each other. On the internet, no one knows you're a dog. Well, on the internet, no one knows what a nice person you are because you're acting like a jerk quite often. And some of us have experienced that with emails that we've gotten from maybe work colleagues or even from families or friends. But you know where else we see it is in comments to news stories. So the kind of vitriol that had previously been reserved to websites and then to social media is now infiltrating even the news stories that we read online. After the Madoff affair, the Palm Beach Post decided to shut down the comment section in the newspaper because of the incredible anti-Semitism that was being expressed. Now, many of those comments, if not most of those comments, were posted by people who chose to have fanciful usernames, or who, in other words, remained anonymous. And there is something to this mask of anonymity. The parallels aren't exact, and there are some real legal distinctions, but it's not unlike the masks that the Ku Klux Klan wore. That were ruled illegal, because it empowers you to say and do hateful things that you would not do if you had to be held accountable. And one of the things that I really admire about Facebook is the real name policy, where people have to stand behind what they say. And I think that acts as a real restraint. Now, I think Jeff will address the issue of anonymity. If not, I'll ask him to, because anonymity plays a very powerful role in free expression, too. You go back to the pamphlets of Thomas Paine. Being able to not have to be held accountable for fear of retribution is also important. So there's a balance. And last November, I led a discussion in the New York Times Sunday Review about anonymity online. And it was a decidedly very split set of views. But interestingly, just a few weeks after that, the New York Times decided that people who are willing to stand up for their ideas and use their real names will have their comments to news stories posted first. And anonymous comments will come later and perhaps not even be read, which I thought was a very, very interesting compromise. One recent example of how haters are using the internet occurred on a recent 4th of July. As we Americans were celebrating our Independence Day, there was a new event announced on Facebook. You'll recall this, Judd. It was entitled Kill a Jew Day. And the Facebook host for the event wrote, and I'll quote it, "You know the drill, guys." And he urged followers to engage in violence anywhere you see a Jew between July 4th and July 22nd. And a Nazi swastika adorned the event page. And the posting of that sickening event prompted a wave of anti-Semitic rants on Facebook in support of this idea of targeting Jewish people. But it also prompted a counter event on Facebook entitled 1 Million Strong Against Kill a Jew Day, whose numbers actually numbered more modestly in the thousands. And there were complaints to Facebook. This may have been before your time there, Judd, but the complaints were pursuant to the terms of service that the Kill a Jew Day event violated the terms of service, and the administrators at Facebook terminated that page. Of course, the outrage over that page was justified, not just because of the vile anti-Semitism that was underneath it or because it glorified the swastika. It's because people who saw it know, and I know, that internet messages can and do inspire real-world violence. As Marvin put it, and as Abe Foxman has recognized, the Holocaust did not start with guns, it started with words. And we've seen time and time again how internet words have been associated with some of the worst real-world hate that we've seen. There was an attack on Nobel laureate and Holocaust survivor Elie Wiesel by a Holocaust denier in 2007. He hosted a website that espoused Holocaust denial. There was the 2009 murder at the United States Holocaust Memorial Museum in Washington by a 90-year-old white supremacist who hosted a website and who was egged on by his fellow haters on that website. The gunman who committed the Norwegian rampage last year and killed the children at the summer camp had a website and used the web to interact with fellow haters. There was a Manhasset, New York teen who decided to spray paint swastikas on the headstones at Jewish cemeteries. He was prominent in hate groups on the internet. And I could go on, but the point is that words have consequences, and they often lead to and inspire acts of hate and violence. So one visceral reaction to this is there ought to be a law. And we'll hear from Jeff in a minute why that probably is not possible in the United States, or at least to the extent it is prohibited, the boundaries are very, very broad. And of course, in the European Union and elsewhere around the world, there are laws. And we'll hear from Peter about that as well. And just to pick on Holocaust denial laws, laws against Holocaust denial in Europe as one example, the enforcement of those laws against Holocaust deniers, given the bitterly sad history of the countries where those laws exist, does serve a purpose. It serves as a message to all citizens, especially impressionable children, that it is literally unspeakable to say that the Holocaust did not happen given the horrors of genocide in those countries. But there are many who believe that the prosecutions of Holocaust deniers really serves to glorify them and serves to make them martyrs among their followers. You just look at the case of David Irving, for example, who was prosecuted, and others whose works were taken down in Europe but immediately reappeared in the United States because of the First Amendment. And it is the case that laws against internet hate have done nothing to reduce internet hate. There is an internet hate protocol to the cybercrime treaty that a number of countries have signed. The United States is a signatory to the cybercrime treaty, but not to the internet hate protocol. But in places where the protocol has been adopted, you don't see any less internet hate. In fact, where internet hate is taken down or prohibited, you find the people who want to propagate it coming over to the United States and using the platform that is available to them, and they can come over to the United States, not literally, but virtually, and very easily electronically. Why don't I stop there? I'm going to save some of the other comments that I had here so that we can start the discussion with the panel, and we'll do that, and I'll come take my seat with Jeff, and then I've asked each of the panelists to speak for about 10 minutes or so, 10 or 15 minutes, and then we do want to open it up to questions and discussions.
Thank you so much, Chris. It's a pleasure to be here. It's impossible to imagine a more important topic, and this is a great group, so I'm really, truly looking forward to this conversation. Marvin started us off by describing very succinctly and dramatically the recent saga of the anti-Muhammad video posted on YouTube in September, which set the Middle East ablaze. And after days of rioting in Egypt and Libya, as he said, the US government asked Google, which owns YouTube, to remove the video. Google refused on the grounds that the video didn't violate YouTube's hate speech policy, which bans speech that attacks or demeans a religious group, but not a religious prophet or leader. But Google did block access to the video in Libya and Egypt, and we then had speeches by President Obama and the President of Egypt defending two very different views of free expression. The American view, which says that speech can be banned only when it threatens to provoke imminent violence, and the European view, or Islamic view, which says that speech can be banned when it denigrates or demeans the social standing of a group based on religion or ethnicity. What is the lesson of this remarkable series of events that we just witnessed? For me, the most important lesson is to confirm a truth that's transforming our global debates about free speech today, namely that today lawyers at Google and YouTube and Facebook and Twitter have more power over who can speak and who can be heard than any president, judge, or monarch. I'm not flattering Judd Hoffman to say that in practical terms, he will determine more about who can speak around the world than any justice of the Supreme Court. And that is a heavy responsibility. It reflects the fact that Google and Facebook and other private companies are not formally bound by the First Amendment, although they do pledge to enforce national laws within individual countries when those violations are clear. That's why both Google and Facebook did remove the anti-Muhammad videos in countries that they concluded clearly banned it, such as India and Russia. But given this reality of the power of internet service providers, to evaluate the regulation of hate speech today, we need not only to understand the very different laws on the books regulating hate speech around the globe and the enforcement policies of the governments in question, We also have to understand the definition of hate speech adopted by the leading internet service providers, and most importantly, how they're enforced and by whom. And what I want to argue today is that the ISPs have generally adopted European-style definitions of hate speech, but they're enforcing these definitions in more American ways. In other words, they ban speech that demeans groups. They've come close to adopting a prohibition on group libel, but in applying these prohibitions, they've tended to focus on the presence or absence of threats or imminent violence. And although this seems to me a plausible way of reconciling different free speech tradition, and I very much respect the work that Judd and his colleagues at Facebook and Google as well are doing, I do think that these decisions combine the functions of legislators, judges, and executive officials in ways that in some cases are troubling. And although these deciders are doing an impressive job under the circumstances, more transparency and predictability in the policies might serve constitutional values around the world. So Chris has asked me briefly to describe the US versus the European tradition. Let me do that as succinctly as possible. The European tradition, as I said, allows the regulation of group libel, defined as speech that denigrates the dignity of a group, or defames it, or lowers its standing in society. The point is not to ban offense. The idea is that when the dignity of a group is demeaned, it may no longer be able to participate in equal citizenship. And MySpace, for example, adopts the European definition when it prohibits content that targets a group in a way that would make group members feel bad. For this reason, MySpace made an easy decision to remove Holocaust denial sites. The American view is very different. According to the US Supreme Court, the First Amendment prohibits the regulation of hate speech unless it threatens to provoke an imminent violent response and is likely to do so. And this towering achievement of the American free speech tradition was originally introduced in debates over the constitutionality of banning seditious libel. In other words, speech that insulted government officials, and this was embodied in the Sedition Act of 1798, which made it a crime to publish false, scandalous, or malicious writings against the government of the United States, including the President or Congress, with intent to bring them into contempt or disrepute, or to excite against them the hatred of the good people of the United States. The Sedition Act was vigorously criticized as unconstitutional by both Madison and Jefferson in the Virginia and Kentucky resolutions, and the Supreme Court finally recognized this view by repudiating the possibility of banning seditious libel in the New York Times and Sullivan case in 1964. The central meaning of the First Amendment, said the Supreme Court, is that seditious libel cannot be made the subject of government sanction. A public official suing for defamation has to prove actual malice, in other words, actual knowledge of falsity or reckless lack of investigation. As for speech directed at private groups, the court resolved that tension as well in favor of speech in Brandenburg versus Ohio in 1969. This involved the conviction of a Ku Klux Klan leader who violated an Ohio law that prohibited advocating crime, sabotage, violence, or unlawful methods of terrorism as a mean of accomplishing industrial or political reform. A Klan leader made racist remarks about sending the Jew back to Israel. He was convicted, and the court struck down the law, holding that the constitutional guarantees of free speech and a free press do not permit a state to forbid or prescribe advocacy of the use of force or law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Notice how rigorous that test is. There has to be both an intent and a likelihood of success. The test, incidentally, is a vindication of Justice Brandeis's test for evaluating subversive advocacy in his great concurrence in the Whitney case. So under the US tradition, mere advocacy of hate can't be banned unless it's an incitement to imminent lawless action and is likely to succeed. And the result is that hate speech in the US is very hard for governments to regulate. Europe regulates group libel, America doesn't. All right, that's my professorial summary of the law in response to Chris's request. But we can't understand anything about how hate speech is actually regulated today if we don't look beyond the law and how individual user policies are adopted and enforced by the internet service providers. And I want to give a brief overview of how Google, Twitter, YouTube, and Facebook adopt and enforce their policies, and I'm so looking forward to Judd's illuminating us with greater details. So what is YouTube's hate speech policy? On YouTube, Google's policy is to remove content only if it's hate speech, violating terms of service, or if it's responding to valid court orders or government requests. Under the YouTube terms of service, hate speech is defined as speech which attacks or demeans a group based on race or ethnic origin, religion, disability, gender, age, veteran status, and sexual orientation or gender identity. Sometimes there's a fine line between what is or what isn't considered hate speech. It's okay to criticize a nation, but not okay to make insulting generalizations about people of a particular nationality. That's why Google refused to remove Innocence of Muslims from YouTube completely, because it mocked Islam, but not the Muslim people, and therefore did not constitute hate speech under the European policy. Well, that sounds quite European in prohibiting videos which demean or lower the status of a group of people. But when it comes to enforcing this hate speech policy, YouTube seems more American. It aims, quote, to draw a careful line between enabling free expression and religious speech while prohibiting content that incites violence. How is the YouTube policy enforced? I had the privilege of visiting YouTube and Google in 2007 and walking around YouTube headquarters in San Bernardino County, and I saw a bunch of 22-year-olds all wearing flip-flops and t-shirts hunched over their laptops. And I was told to try to figure out who the content reviewers were who were reviewing user flags and deciding what violated the policy or what didn't. I couldn't, because everyone looked exactly the same. And my Google host said, well, you can tell by the porn flickering on their laptops. So these first reviewers are making spot decisions about whether or not particular forms of nudity are or are not illegal. Imagine the power and complexity of these judgments. And controversial judgments can be filtered up the Google and YouTube hierarchy until they reach the woman who at the time was responsible for making the final decisions. Her colleagues actually called her the decider. Her name is Nicole Wong. She recently left Google, but she had the ultimate authority, playing a role similar to that Judd and his colleague Dave Wilner, I guess, at Facebook do, in basically adjudicating these complicated cases. And she did a great job, I think, but she told me in interviews that she felt quite overwhelmed by this task and would have preferred that democratic bodies elected around the world told her which videos to remove, because it was a big job for one woman. She'd be woken up in the middle of the night by requests from the Turkish government, which was objecting because Greek football fans were posting videos saying that Kemal Ataturk, the founder of modern Turkey, was gay. This is not true, but it's very illegal in Turkey because you can't in any way demean the founder of modern Turkey. And she had to decide, she doesn't speak Turkish and it's 3 in the morning, and she has to decide what videos are clearly illegal under Turkish law, and they come down, which videos criticize a political party but not Kemal Ataturk, which stay up, and what are the gray areas. So that just shows the complexity of the task that was set for Nicole Wong, and she resolved it by blocking access to the videos that were clearly illegal in Turkey itself, using a technique called IP blocking. That wasn't enough for the Turkish government, which demanded the removal of the videos across the world on the ground that someone somewhere in the world might be offended by these videos. Google refused, and for a long time, Google itself was blocked in Turkey. So this is the way these regulations actually operate. What about the other internet service providers? Twitter has a more American definition of hate speech. Unlike Google, Twitter doesn't explicitly address hate speech, but it says in its rule book that users are allowed to post content, including inflammatory content, if they don't violate the Twitter terms of service, which prohibit direct, specific threats of violence. And the content decisions there are made by Twitter's trust and safety team, headed by Del Harvey. As for Facebook, I'll leave it to Judd to tell us how it works. It's tremendously important, the procedure that they have set up, and he can tell us what the policies are and how they're actually enforced. I do want to note just one example of a takedown request at Facebook that I think the company acknowledged in retrospect may have been mistaken, and that was because of the automated nature of the initial response. What happened here was there was a debate over the construction of an Islamic cultural center not far from Ground Zero in Manhattan. You remember this story, Judd. Sarah Palin posted a note on Facebook responding to a statement by Mayor Bloomberg supporting the center. Palin's note criticized the Islamic cleric who would lead the cultural center for what she classified as extremist views, and said a project supported by such a person should not be approved. In response, some internet commentators reported Palin's comment to Facebook as hate speech and urged others to do so. Facebook deleted the post. Facebook later released a statement apologizing and claiming that, quote, the node in question did not violate our content standards, but was removed by an automated system. So this raises the important question of what degree of due diligence internet platforms like Facebook believe is necessary to oversee these mechanisms and practices. What are the lessons? I hope in our discussion, as I conclude these initial remarks, we can talk together about ways that these definitional terms of service policies might be made more precise, and most importantly, how the enforcement can be regularized along with transparency and oversight. My instinct is to narrow the definition of hate speech toward a more American definition, focusing on specific threats of violence against individual or groups, and rather than prohibiting speech that demeans groups or lowers their social status, which seems to me far more difficult in practice to enforce. Jeremy Waldron, the leading advocate for this European-style focus on dignitary hate speech, is unable, clearly in his recent book on hate speech, to tell us whether or not the famous anti-Muhammad cartoons, the Danish Muhammad cartoons, are or are not hate speech under his own definition. And if a brilliant law professor like he can't apply his own definition, I think it's unrealistic to expect the 22-year-olds in flip-flops in San Bernardino County to do the same thing. So my preference would be for a focus on threats of imminent violence against individual or groups, but that still leaves the question of who decides whether or not the threat of violence is imminent. And Tim Wu, a great internet scholar, has recently proposed creating local bodies of either users or experts that would either definitively decide or make recommendations to Facebook and Google about what sort of speech is likely to cause violence in particular areas. That is an interesting suggestion, although it does raise the possibility of a strong heckler's veto and might protect less speech than the current decider models do. My tentative thought, and that's just to throw in to begin our discussion, is that it would be good to regularize the standards for identifying when violence is imminent. And I think, Judd, I hope you'll be able to say more about the Facebook standards that demand time, place, and manner and credibility of threats, and the question of how deciders could determine whether or not a threat is credible and how likely violence is to occur would be tremendously useful. But such an exciting topic for a free speech scholar and for a citizen, it's impossible to imagine greater opportunities to recreate anew in cyberspace the protections that in real space our Constitution protected for so long. Thank you so much, and looking forward to the discussion.
Thanks, Jeff, very much. And before we call on Peter, if you're interested in reading more about the decider, wasn't that the subject of a New York Times Sunday Magazine article that you wrote?
It was indeed.
So you can probably find that online. And I'll let Professor Waldron make his own brief, but I do want to note that he thinks that we've overprotected speech. And he says it's overprotected because a lot of speech, and not just that which threatens imminent harm, causes a significant harm to the dignity of minority groups. And also deters people from participating. Our friend, Professor Daniel Citron, says that a lot of misogynistic speech literally scares women off the internet so they don't participate. And Waldron also says that the public good of inclusiveness that's an essential attribute of our society is really diminished by a lot of speech that we embrace as permissible. And he believes that regulation would be desirable not just to protect targets of hate speech from offense, but also to protect a social environment, this is how he describes it, polluted by anti-gay leaflets, Nazi banners, and burning crosses that send an implicit message to targets of such hatred that your security is uncertain and you can expect to face humiliation and discrimination when you leave your home, even if the threats aren't imminent.
You've summarized him very well, and I hope we'll talk more about him. I'm just struck initially by how little he says about the internet and how his vision that pamphlets can make someone feel unsafe and credibly fear violence in a real space community doesn't apply at all online, which is not a place where civility reigns, where many threats are preposterous and not at all credible. And this effort to transmit onto the internet community standards that makes sense in real space seems to me a weakness of the argument.
Great. We'll get into that in a bit, I'm sure. So Peter, if you could give us the perspective from the EU.
Yes, I also welcome everybody, and I would like to thank new friends at the Houston Law Center and at the ADL in Houston, who with Chris, and who together made this conversation possible. And it's really a pleasure, and it's inspiring to talk after 3 thoughtful presentations. And so I will talk about several connected things. First, I would like to mention that, and thanks Chris for mentioning it, that the flyers of the book that I co-edited with Michael Hertz, a friend from Cardozo Law School, are out there, and I encourage you to get the book because it really provides a broad picture of how so-called hate speech is responded to in very different environments, from Australia to Canada to Latin America to Russia and all sorts of places, Ethiopia and really different cultural environments. And the starting idea of the book was right to the topic. It was a cross-Atlantic comparison to look at to what extent and in what ways the constitutional treatment of so-called hate speech is different under the First Amendment and under Article 10 of the European Convention on Human Rights. Then it became a lot broader, as I just described. It became a fully global comparative book on the subject, and it includes a chapter on not only on the Council of Europe policies in order to respond to so-called hate speech, including extra-legal public policies, and in a way, most importantly, the jurisprudence of the European Court of Human Rights in regard to this subject. But for example, Eduardo Bertoni, a friend from Buenos Aires, wrote up a chapter about the similar practices under the Inter-American Convention on Human Rights. And I would like next to talk a bit more about the European Court of Human Rights and Hungary as a European example, and with total respect and friendship, I would like to say that there is no such a thing as Europe in general. So it's a diverse picture, and I will provide a few examples that will illustrate that. So Jeremy Waldron argues that one of the tries what he makes, and perhaps it's more than a nice try, that he makes the argument that some debates might be settled while others not. So for example, the debate about the Holocaust or the debate about the genocide in Rwanda or in Srebrenica in former Yugoslavia, we might get to know more detailed facts, but it seems to be settled that those were terrible atrocities. And then in some countries, people might want to say that we don't want to hear questioning that because that's just the truth. And of course, we can bring up a whole list of counter-arguments against that point, but I mentioned this argument of Jeremy because the European Court of Human Rights in the Ferret case, a Belgian case, which included anti-immigrant speech of a political party and one of its leading politicians, the majority of the court in Strasbourg said, upheld the restriction to that speech as sort of so-called hate speech, but very importantly, there were dissenting voices, and a very eloquent dissent was written by a wonderful friend, András Sajó from Hungary, who founded the Comparative Constitutional Law program at the Central European University in Budapest. And now he's a judge on the European Court of Human Rights, and he argued that the restriction was not justified. And then he was criticized, interestingly, by someone in Hungary saying that he was using a double standard in a way because the court has jurisprudence on upholding decisions against Holocaust denial, while in this case, András argued that the way I just mentioned. But I think that maybe a distinction that Jeremy Weldron argued for might support the differentiation between those cases. And I mentioned this example also because at the same time, in the infamous anti-Muslim speech in the case of the infamous anti-Muslim speech of Geert Wilders in the Netherlands, his speech finally was not successfully prosecuted. So it's very interesting. Again, there is no such a thing as the European approach because both speech was kind of anti-immigrant. In one case, the Dutch law enforcement system said it was part of freedom of speech. And on the other hand, next door in Belgium, similar speech, court said it's beyond the limits, and European Court of Human Rights upheld it. So then let me mention Hungary. So Hungary lost many Jewish Hungarians and Roma Hungarians in the Holocaust. So I think there is no country which could feel more. There are countries, unfortunately, which could feel the same strength, the same strong way to prohibit anti-Semitic and anti-Roma and other racist views. But the courts in Hungary, although it's somewhat an outlier in Europe, but still it's Europe as well, the middle of Europe, Central Europe. So courts in Hungary, with the support of some of us, developed a version of the Brandenburg test, the imminent danger test, and I think it's a striking example because it shows that all those arguments that provides that the bit less dark 20th century history of the United States explains why in the US there has been no need for content-based prohibitions, or in part explain that. In Hungary, of course, I can add that perhaps it was a huge mistake, unfortunately, but so we went the similar way. And let me mention a very creative court decision when describing the relevant case law in Hungary. An exceptional criminal law prohibition of so-called hate speech, what can be characterized as hate speech, is a Holocaust denial ban since 2010, and the current right-wing government added the ban on denying the crimes committed by the communist regime. And so the first case that was tried under this law brought a, I think, very creative decision. The judge gave suspended prison term for the person who denied the Holocaust, but of course that's very debatable whether that's justifiable restriction to free speech or not. But very importantly, the judge said that the person who denied the Holocaust can choose. Either he should visit 3 times the Holocaust Museum in Budapest, or he should visit Auschwitz once. I would say that he should do both. But so that's an interesting way of combining, I think, education with law. And closing my introductory comment, I would like to say quickly just a few things about internet-related issues, also that could connect well to the next speaker. And just 2 points quickly. One, that I would love to hear your opinions about how how incitement to hatred on the internet, in light of the new technological developments that put mobile devices through which internet is accessible wherever or almost wherever into the hands of more and more people. So to what extent and in what ways this technological development has been turning the internet into an instrument of what I call instrumental incitement to violence, in a way where it seems to me that even under the First Amendment or under the constitutional interpretation of freedom of speech in Hungary, it should be prohibited under certain circumstances. The other issue I would like to raise, and I'm close with this, so it's about the role of intermediaries and internet intermediaries. So it seems to me that the argument that certain internet companies became so powerful, and it's almost like if someone cannot be on Facebook, that person might have doubts whether she or he exists at all. So it can support an argument that those companies do not have the right to restrict free speech and exclude those who, under some sort of definition, would engage in so-called hate speech. It seems to me that the argument can go the other way as well. If we say under the American and similarly under the Hungarian constitution that instead of content-based restriction by the state, we, the civil society, should push back hateful expressions, then it seems to me that the more powerful, more influential a private company that is committed to do that, the better job it can do in order to fight racism. But then, of course, unfortunately, the doubt comes to my mind, because the question is that whether such restriction would restrict the freedom, for example, to communicate legitimate criticism of whatever religion, according to the values of the Enlightenment, according to the values of freedom of speech, in the history of which it has been a very integral part that we fought for the right to ridicule, attack any religion, no exception. And in that regard, the British regulation, I think, is fascinating. When in the regulation about incitement to religious hatred, there is an additional provision which says that the restriction to such speech does not mean, and then there is a long list what people can do: ridicule, attack, criticize religion. I don't quote by word, by heart. But so in that sense, it seems to me that the role of the intermediaries in this fight, it's really crucial. I think I am very much inclined to support it, that they should take a role, but we have to be very careful, of course, that we should not produce an example when such self-regulation would bring more restriction than what restriction by the state, like the British example, would bring in a certain subject. Thank you so much for your attention, and I'm also looking forward to the continuing conversation.
Peter, thank you very much. And as Judd walks up to the podium, please go ahead, or you can sit there wherever you'd like to do it. You're really on the spot now, coming up last after all of this. I hearken back to an early internet judicial decision involving Prodigy. Anybody remember Prodigy? One of the original services. Prodigy said that it was the family-friendly internet service, and when something that wasn't so family-friendly got online, they were sued, and there was actually a rather unfortunate decision which ultimately led to Section 230 of the Communications Decency Act, which is an adjunct to the First Amendment and allows service providers, platforms like Facebook, to make decisions about what's in bounds or what's out of bounds, but most importantly, not to be responsible for the content of your users. If that law was not in place, Facebook wouldn't exist and it wouldn't have reached its 1 billionth user as it did today. But with that power, as you've heard today, Judd, comes a lot of responsibility. I think there's a difference in opinion on how that power should be exercised. I think the ADL's view is, and maybe it's simply aspirational, that the internet can be a more civil place, a more civilized society, and that the test isn't necessarily whether the speech is about to trigger a wave of violence, but whether or not it really does offend the dignity of people. And so we're really interested in hearing how you assess these points, how the decisions are made at Facebook, and what input civil society has into that decision making.
Thank you. Yeah, so I think what I'd like to do and what I'm prepared to do here is to talk a little bit about my team, what we do, the way in which we actually develop the policies that we have, and then how we enforce them. And then I'll talk a little bit more specifically about when something is reported to us, how that's handled logistically. And then we can talk about some more specific examples maybe in the panel discussion where you or others may have specific facts that you'd like to talk about or specific cases. So my team, so and thank you, by the way, for having me. My name is Judd Hoffman. My title at Facebook is Global Policy Manager. And what that means is that my team of 9 people, we're in 2 offices, plus other contributors who in the process of developing and enforcing the policy and in 2 other offices, are basically responsible for creating and interpreting and managing the rules that govern users and developers and marketers' interactions with Facebook and with each other on the Facebook platform. My team resides within the Global Public Policy team and is responsible for managing the community standards, which is our outward-facing set of policies regarding the content that is allowed on Facebook. We'll talk mostly about those, I think, here. We're also responsible for the advertising guidelines that govern what types of advertising, what types of products, the way in which those are advertised are allowed on Facebook. The product-specific terms like pages terms, what types of content are allowed to be on pages, how people can use pages and other products within Facebook. And then finally, the platform policies, which is the policies that govern the way in which developers who are developing on the Facebook platform can develop apps that use Facebook, what those developers can do with the data that they receive from Facebook, that sort of thing. So that's obviously a broad remit. I think the most applicable element of that we're talking about here, especially with respect to the focus on bigotry and racism and hate speech on the internet, is our what we call our content standards that are in the community standards that we have published. And the way that we develop those rules basically goes back to the mission of the company. Facebook's mission is to make the world more open and connected. And what that means to us is that we want what is now a billion people of all cultures and nationalities and creeds and ages above 13 to use our platform to connect and express themselves freely while still respecting the rights of others. So in order to create a philosophy on which a framework for those policies can be built, we've spent obviously a lot of time thinking about it. And to be honest, the first rules that we had were not based on any philosophy at all. To reference Jeff's reference at YouTube to the 22-year-olds in sandals or flip-flops, that's how Facebook started as well. And Dave Wilner, who is on my team and primarily responsible for these content standards, started at Facebook right out of college, 22 years old. Started on the enforcement team that we have that actually makes the decisions about whether or not content violates our policies. and was frustrated by the fact that he didn't have much more guidance than a set of rules that were put in place in front of him, and said that, and he was told to enforce these. So if you see this, do this. If you would see this, do this. There was no reason. It was just reactive and a subjective decision about what was allowed and what was not allowed. This was probably 2007. So he decided to fix that and started working on a set of content standards before I even arrived and before this team was formed, to try to develop some sort of a framework, and got a good ways there. And since I've started, we've done more. And the philosophy that we've developed, given the strong focus on Facebook's mission, again making the world more open and connected, is we've essentially adopted John Stuart Mill's harm principle, which is we will give everyone the power to share content as long as it doesn't harm someone else. So the default for us is something is allowed. We have to have a reason to take that down. And that reason has to be more than it doesn't add value, or it's offensive to me. It actually, the line that we've drawn is between harm and offense, to the point that it needs to be harmful. So that obviously begs the question, what is harmful? Our definition of harm is organizing real-world violence, theft, or property destruction, or inflicting emotional distress on a specific private individual. Which is an easy definition to recite. It's extremely hard to apply in principle, and requires a lot of context, frankly. We allow people to use language and images, even when they're extremely offensive or inaccurate, to make jokes or express political beliefs that aren't genuinely or directly harmful. We've also found, frankly, that the discourse that content sparks often results in the number of people denouncing offensive speech vastly outnumbering those who have produced it. On the context question, though, the other thing to understand is that, and I'll talk a little bit about how our content is reviewed, but we have hundreds of people who are in what's called our user operations team that are responsible for enforcing these policies. Some of them are the 22-year-olds in flip-flops, extremely intelligent, very dedicated, amazingly innovative people, despite their age, that do a fantastic job of doing exactly that. What they are tasked with, though, is responding to reported content that they're reviewing and making decisions within a few seconds about whether or not that violates our terms. To give you some context, just in the photos realm, there are over 200 billion photos on Facebook, and more than 200 million are uploaded every day. Our user operations team deals with well over 2 million reports a week, and that a few hundred people within our organization are tasked with responding to. And so, despite the fact that in a lot of cases, all of us here could take a specific example and talk it through and argue it and maybe even come to consensus on the outcome of that, those people don't have the luxury of the time, the context, the understanding of being able to see the intent of the person that had posted it, et cetera. And so part of what we're tasked with is making rules that can be executed. And so what we try to do is to be very specific in the instruction that we give to people about those policies. So as I had mentioned before, the enforcement teams, there's a few of them. The one that responds to the reports of content that violates our standards is called the user operations team. They're responsible for enforcement of those community standards. There are 4 teams within the user operations group. There's a safety team, a hate and harassment team, an access team, and then abusive content teams. And they obviously are responsible for dealing with different types of violations of our terms. Those 4 teams together constitute a few hundred people in 4 offices on 3 different continents, and then a limited number of contractors in a couple of other offices. The way that it works, as I mentioned before, is that the content that is reported is routed to somebody. Those people are making decisions. If they are unable to make a decision, those tough calls are escalated up through and ultimately end up with me and sometimes my boss and sometimes my boss's boss. But to use the example that Jeff had given, I guess I'm the equivalent of the decider in this case as well, and take that responsibility extremely seriously. As Chris mentioned, we hit 1 billion users, or we announced that we had hit 1 billion users today. And every once in a while, it's probably on a weekly basis, I'm reminded of the impact on an individual basis that the decisions that we're making make for people. Both people who are extremely upset because we made a decision to take something down that they thought was absolutely appropriate, and also situations where we refused to take something down where someone thought it was absolutely inappropriate. But ultimately, this is a personal business where the decisions that we're making, while we're trying to be extremely principled, actually have real-world effects. So the last thing, just to give you a little bit of context on what happens when you or someone you know reports a piece of content, whether it be a photo or a status update or anything else that someone posts or shares on Facebook, what happens with that? As I mentioned before, hundreds of billions of pieces of content already reside on our servers on Facebook as a result of the things that people have saved or shared already. Hundreds of millions of photos uploaded every day, hundreds of millions of status updates every day. All of those things can be reported. And there's in most cases, the upper right-hand corner, there's a little X. It allows you to choose the reason why you're reporting something in 24 different languages. And what happens is that report goes into a queue. And these queues are staffed by the different teams that I had just mentioned. And those people are making decisions on whether or not it violates the standards based on the guidance that my team gives them with respect to our policies. So the turnaround time for those queues are prioritized. To use an example, if someone's reporting nudity, for example, which is against our terms, the turnaround time on that is going to be longer than, for example, someone who is threatening suicide. And the process by which we handle those reports is obviously different as well. Law enforcement is involved in some cases, counseling is involved in some cases for the suicidal content, threats, that sort of thing. But all of the reasons why someone would report something in each of those queues have different prioritized turnaround times. There are a few different outcomes that can result from that report. So one is that we would ignore it. And ignore is essentially means that we've reviewed the report, we've compared that against the policy, and there's been a determination that it doesn't violate the policy, and nothing happens, basically. We can warn a user and tell them that they have violated our policies, that we've taken down a piece of the content that they've put up, and that if they do it again, a series of increasing penalties will apply to them. We also generally will just remove the content that violates the policies altogether. We also have the ability to block certain features. So if somebody, for example, they continue to upload photos that are inappropriate and violate our policies, rather than disabling them altogether, we can just make it impossible for them to upload photos for some period of time, which is actually one of the things that we've done to great success, and put them through an education program, essentially. So it requires them to go through, and in order to get the ability to upload those photos again, they have to go through an online education checkpoint. And then finally, the kind of the worst thing that we can do beyond the situations in which we would report incidents to law enforcement would be to just disable their account altogether. One of the things that we have rolled out recently is a dashboard that everyone can see what the result of the things that they've reported. So it used to be, even just a year ago, you reported something you didn't like and it was ignored or action was taken. The person who had reported it didn't actually know what had happened. And that capability exists now for you to go in and through this reporting dashboard. When we take action or decide not to take action, we document that. And so you can go back and look and realize that or understand that item 1 that you reported violated our terms, but item 2 didn't, and here's why. So, I'm really happy to be here. I'm extremely happy to talk a little bit more about some of the things that we've been thinking about, transparency being number 1 among them. And I know Jeff had mentioned that as well, and look forward to the conversation. So thanks again for having me.
Thanks very much. It really is very illuminating, very helpful, I think, for the discussion. Google's not here to represent itself, so I did want to mention one example, one episode that the ADL had with Google where they said it wasn't appropriate to take down content, but the discussion didn't end there. There is a virulently anti-Semitic group known as Jew Watch, one of the first hate groups that had a website and promotes that website, and their website gets a lot of traffic. So as a result, for at least some period of time, it was the #1 ranked search result if you put in the term Jew into a search engine. Now, most people would put in Jewish or Judaism. Jew is not a typical friendly search term, but still is one that's used. And so the ADL went to Google and asked them to disable that link. This was before my involvement, and I would have told them they're not going to disable the link, and the answer came back, we're not going to disable the link. But the ADL said, we want to have more discussions with you. And so the solution actually was a very useful compromise, and I think it's an example of how intermediaries working with NGOs and concerned people can come up with solutions. And that was to have a free sponsored ad that would float with the search results for Jew Watch, no matter where it appeared in the listing, that said, this search result over here to the left or underneath is a link to a hate site. And for more information about anti-Semitism and hate sites, click here with a link to the ADL. Likewise, on the YouTube service, they have a hate center where you can get information about how decisions are made and what is hate speech, and there's a link to the ADL. Now, I'm not just in favor of things that link to the ADL, although that's not a bad thing, but I think the point is that there are partnerships and alternatives to simply blocking speech. You mentioned, excuse me, you mentioned counter speech, and it's something that obviously is a very powerful antidote to hate speech. It's the one that Justice Brandeis talked about, and one that any proponent of the First Amendment talks about. You can have the same First Amendment platform to speak out. The fact is that most people don't and aren't as motivated to engage in counter speech as the haters are to engage in hate speech for whatever reason. And one of the messages that I take to ADL groups is that if you see something, say something is not a slogan that just applies for airports and bus stations. That if you see content, although you have plenty of reports, enlightened, educated reports would be a good thing to have from a group like this if they see hate speech that violates the terms of service. So just a little fill-up on the Google experience and the ADL's views. I'm seeing that we're almost at 4:30, and I think we're supposed to end by 5. Why don't we take questions from the audience, and then I'll mix it up with a few other questions along the way. And Marvin, any questions that you may have?
Well, I certainly want to encourage the audience to participate. I would ask you that when you have a question, that you try to pose it in the context of a general question as opposed to some personal incident that I think it's going to be more challenging for the panelists to try to answer. I do have a question that I'd like to pose to the panel. I was taken with Jeff's comment that justices on the Supreme Court have less power over what's said on the internet than perhaps what Facebook or Google or someone else permits. And in the context, Judd, of talking about what Facebook does to monitor its site, what training, what experience, what qualifications do your watchers have? I mean, how are they equipped to deal with these issues and make these sort of instant decisions that you spoke about?
Yeah, so there's an extensive training program that people go through. First of all, just within user operations in general. So when you come in and this, and oftentimes is a first job out of college, entry-level position. The user operations has weeks-long training just to understand user operations in general. But then there is also specific training depending on the team that you join. So to give an example of one of them where they get the most extensive training, we have a team of people who are reviewing and working with the National Center for Missing and Exploited Children. And their job is to review reports of child pornography and child exploitative materials. And the result of that has been a fantastic partnership with NECMEC and with law enforcement and with other internet intermediaries, and we've done a really good job and are commended on the work that we've done on the safety perspective of that. But what happens is that you have people who are exposed to very troubling material all day long. And so we, in addition to the simple training to make these decisions, also have counseling services and training ways to deal with the content that they're seeing and the decisions that they're making, and understanding the impact that they're making in a broader scale, to try to make sure that we're doing the right thing for the employees, but also getting the best results in the decisions that they're making. Does that answer the question?
That's very helpful, yes.
You know, one of the things we haven't talked about explicitly here is cyberbullying, which is something the ADL is very involved with. We drafted the first model anti-cyberbullying law, which is not a speech controlling law, but one that instructs school systems to address this issue and try to provide training and education. So in addition to counter speech, education is a huge tool that can be used to fight cyberbullying, but hate speech of all kinds. And it's remarkable how little cyber literacy education there is generally in our school systems. For a while, it was kind of cute for the parents to say, you know, I'm new to technology, my kids have grown up with it, so how am I going to supervise them? They're the digital natives, we're the digital immigrants, we'll let them really teach us how to do that, and frankly, it's a cop-out. Because no parent would let their kid go out onto a city street without some guidance, but there are plenty of kids who go onto the internet without a lot of guidance, and the result is that they are either the perpetrators of cyberbullying and maybe grow up to be cyber haters, or they're the victims of it. So I wondered how Facebook deals with, I know you don't let kids under 13 on, but teenagers are particularly pernicious in this regard. I wonder how Facebook deals with cyberbullying.
No question, yeah. So this is a perfect example of one of the, and I had alluded to it in the 10 minutes that I had earlier, where context is so important and frankly is something that we don't have in most cases. So the example, so we've mentioned my colleague Dave Wilner, he and I use this all the time as an example, and that is that someone can say, Judd is really good at his job, as a status update. And to some people, they would know that that's absolutely not true, know that that's not true. Other people would interpret that as a joke. Other people would interpret it as a mean dig. And the context and the understanding of the intent of the person that had said that is ultimately important. We can't make a determination based solely on the text of whatever was just said as to whether that's intended as mean and qualifies as cyberbullying, or if it's actually a compliment. And so the way that we've handled that is twofold. One is that under kind of standard definitions of bullying, we've essentially assumed away some of the context that we don't have. So for example, one of the requirements in order to satisfy the general definition of bullying is that it's repeated, that this is not the first time that somebody said it. That there's an imbalance of power, of social power, between the person who is saying it and the person who is the victim. All those things, again, we don't know, and so we assume that they exist. So we are assuming, for example, in most of those in those cases, that it has happened before. We are also assuming that that balance of power, or that power imbalance exists. And so we're left with the report from the person who's saying this statement is bullying me. So in those cases, we act on that. Basically, if someone has reported a comment that says that this is bullying, we will respond by taking that down. The other thing that we've done, though, in cases where it's close and we acknowledge that we may be making the wrong call given the lack of context, is we've instituted something called social reporting. And what that does is allow people to basically designate somebody, a friend, a principal, an adult friend, somebody, as somebody in the real world that they can report this conduct to, as opposed to just sending it to Facebook, who has none of that context. And so we've seen really great strides there in allowing people and allowing kids who are often the victims of cyberbullying to resolve these situations by including somebody who does have the context and is involved in the situation that has sparked the bullying in the first place.
So, Peter, you said, I think I wrote this down correctly, there's no such thing as a European approach, but I would differ with you a little bit, because the Europeans do at least contemplate speech codes, laws that regulate speech, and they impose liability on the Judd Hudsons of the world. I mean, we have a friend, Peter Fleischer at Google, who was convicted in an Italian court for, quote unquote, permitting a YouTube video of a child being bullied to be posted. Of course, it was one of the 60 hours of video that gets posted every moment. I'm sure you have a duel with Google on statistics about how much gets posted by third-party users. But there is this, while there may be differences between Hungarian law and British law and French law and German law, the European approach does comprehend speech codes, right?
I mean, we might say that the sort of like maybe we can say that the mainstream European approach is that, but I think that having Hungary as an outlier there is especially important, because it's really a lot. It does mean a lot more than if, let's say, Sweden or Norway would have been an outlier. So one of the countries where, again, many people died in the Holocaust. And that is a European country which says more speech is the better answer. That's a European answer from the very middle of Europe. And it influences other parts as well. And I think that the difference I described in the legal treatment of the anti-immigrant speech in the Dutch context, and there's just one example, I don't mean to generalize on that, but this is a big example. Wilders, as an anti-immigrant, anti-Muslim party leader, a powerful person, that's a huge example. So and also, how the British regulation is a lot more narrow than some other ones. So I think that it's important to see those nuances also, because if the internet intermediaries, as Jeff described, apply a content-based restriction, which might be just a fine way to go as part of civil society response to racism and other ugly incitement to hatred, then it seems to be very important to take the narrowly tailored examples of how to do that, because if the definition of so-called hate speech you work with would build on, for example, the British restriction on the restriction of speech that some people might find offensive because of their religious beliefs, then it would, for example, help saying that a video which ridicules whatever religion, Islam, Christianity, Judaism, whatever religion, is just not so-called hate speech under your definition, if that provision from the relevant British regulation is part of your definition, that the restriction cannot mean that someone cannot ridicule, criticize, and so on and so forth, any religion. So I think it's very important that whether if internet intermediaries go by sort of by content-based concepts of so-called hate speech, it's really important that they take a narrow concept on each issues, or in general as well. And regarding to that, just two quick questions, if I can raise about about this. One is that you mentioned that, if I understood well, that causing distress is part of the definition you work with. And if I didn't misunderstand that, so isn't that too broad? Isn't that, because it seems to me that lots of speech causes distress, and we need to live with that if we want freedom of speech. And the related question is that to what extent you think that you can mix perhaps a content-based policy on so-called hate speech with a policy of restricting such speech, because in the given context it creates imminent danger of violence, or probably we can think about not only violence, the imminent danger of which we should stop. And again, I would like to bring up the impact of the mobile devices, because I think that's really important, because if your policy is to take down things that cause imminent danger, if part of your policy, if it is part of your policy, then I think it really matters a lot that earlier people read something on the internet and later they attended an event where some neo-Nazis were going to attack either Roma Hungarians, bringing an example from Hungary, or the LGBTQ parade in Budapest, bringing another example from my country. These days, when they are there at the so-called counter demonstration or the racist rally around the buildings of Roma people, they just look at the internet, inciting internet content on their mobile devices right there at the event, if they would have doubt whether they should act violently to stop the LGBTQ parade.
So as I understand the question, one is part of your standard whether content causes distress, and the other is, how does your kind of methodical review process deal with the instantaneous provocation that mobile devices could allow?
Yeah, and I think just the definition of incitement falls within there as well, which is something we spend a lot of time thinking about. So the first one is, yeah, so the standard that when I was talking about harm, language is important, and so that's why I'm looking back at it again as well. Directly inflicting emotional distress on a specific private individual is the standard. So general distress, meaning offense to somebody about anything, does not hit that standard. That's our best shot at explaining why we prohibit bullying, but don't prohibit offense committed to anybody else. And I'm the first to admit, and everybody on the team will admit, that our standards are not perfect. We're constantly trying to improve them. It is a spectrum there in between what we're trying to protect and allow, and specifically allow, which is we acknowledge that there's a lot of speech and a lot of content out there that will offend people. And we're okay, and we actually think that it's a good thing that people talk about those things. Bullying, on the other hand, harassment, causing that intentional emotional distress on a specific individual, however, rises to the level that we believe is harmful. And so that's the distinction that we make. It has to be of a specific individual, specific private individual. Because we also think that it should be okay for someone to talk about people in the news and criticize things that someone has done in the news that if that person were private, we would take down. To your second question about prohibiting content because we believe it will incite violence, we actually don't do that either. So we did not take down the Innocence of Muslims video that despite the fact that we understood that there was going to be, and we were surrounded by people who were taking taking violent action in the name of being severely offended by that. What we did do, and what Jeff alluded to, is in countries where that content was illegal and the law enforcement gave us specific instructions requesting that we take it down and proof that it was illegal, we IP block it within that jurisdiction.
Well, what about content that not only has the tendency to incite violence, but actually calls for violence?
So that's the distinction. If it is calling for or organizing the violence, we will take that down.
So that's easy to state, not so easy to apply. We had an episode with Facebook, the ADL, when I say we, involving the Third Intifada group.
Yes.
And we explained what Intifada was, and this, I don't know whether you were involved.
I was
in this.
there. Yeah, this was right after I joined.
And I think the initial decision was, no, we're going to leave it up. This is a political protest. We're going to have a discussion. But almost instantly, the first several postings made it clear that it was designed to rally people to commit violence against Jews.
Exactly. Yeah. So that's exactly right. Part of the reason that we had left it up is because Intifada on its own, without historical context of the way that word had been used in the other two prior Intifadas, is that it's technically a peaceful protest. There's no violence that is attendant to the term itself, and so we kept it up because of that reason, and because the description of the page itself was that this is intended as a non-violent protest. And so we did keep it up. What immediately, as you had mentioned, what almost immediately happened was not the admin of the page itself, but people who had come to the page started advocating for violence. And we took those down, warned the administrator that if he or she, we didn't know who, he or she didn't moderate that and make sure, because an admin of a page can actually remove the comments on the page or postings to the page. If they didn't do a good job of making sure that they were removing those that were calling for violence, that we were going to take down the page as a whole, because we can't dedicate our staff to make sure that that's staying safe. And ultimately, the admins tried for some period of time, 18 hours or so. We were watching it round the clock. At some point, they either gave up or became overwhelmed, and we took down the page.
Right, just to show how difficult this was in Arabic and English, and some of the content was videos that you had to watch to understand the message.
Jed, can you say more about the standards for determining imminence? Is it just calling for violence that creates the takedown, or does there have to be time, place, and manner, and ability? So can you describe that process, and also are there additional standards or inputs and transparency that would help you make these decisions about whether or not violence is actually imminent? Because it's a very tough problem.
Yeah, it is. I mean, so we have a credibility of threat standard that we apply that basically, as you had mentioned before, requires satisfying three of the following four things: time, place, method, and target. So if any three of those four are satisfied, we've deemed that to be credible. And again, we have to do this on an objective standard because we don't have the context that most people have. Like, even as you and I are sitting here, and you can hear the intonation in my voice and whether I'm standing or sitting and all those kind of things.
But to a point that, Jeff, you made earlier, there is now a process in place as a result of the work you and I have done in the task force on Internet Hate, where we're going to be meeting with the intermediaries to try to provide context and information and have input from First Amendment scholars, but also from NGOs concerned about the content of the speech.
But as we think about that conversation, I wonder, would it be helpful to have, as Tim Wu suggests, local bodies in particular countries, whether of experts or users, who would make a prediction about imminence and whether the violence is likely to succeed? Or would you rather keep those decisions concentrated in Menlo Park and make them in the abstract?
No, so obviously more information is always better. The difficulty that we run into is and I'm struck by this, when I talk about it, when other people talk about it, when people talk about the law and the way the law applies to Facebook, the geographical boundaries and the state boundaries that exist, even if we're just talking about Europe and the United States or countries within Europe or anywhere else, don't exist on Facebook. And so I can have a friend in Israel and a friend in Spain and a friend in India. And they all see my status update, they all see my video, they all see all of those things. And so the difficulty there is, and the reason that we've pushed for global standards is because at the point that you try to say, we're going to follow a particular understanding of what is dangerous enough, what results in incitement, et cetera, you basically set a lowest common denominator standard, right? And so the example that I used, I think, when we were talking before is, and the reason that we're careful about not just removing content because it's illegal somewhere is if we did that, video or images of women driving would not be allowed on Facebook because those images are illegal in Saudi Arabia. And so our job and the way that we see this is that we're trying to be as narrow as possible in those situations. And it is illegal in Saudi Arabia, and we do get the law enforcement there requiring us to take it down or asking us to take it down. And our response is we will block access within that jurisdiction. But somebody in Italy, for example, can still see a video of a woman driving.
So we did have a question from the audience, and I didn't want to overlook it. Sir.
I want to ask you a question about the heckler's veto. And Professor Rosen, let me direct it to you. First of all, great discussion. Thank you all for being here. Obviously, the heckler's veto, the federal courts have stood between the heckler's veto and free speech forever. Are you concerned now that the courts are removed from this circumstance that the heckler is winning? And I'm speaking specifically now of Muslim opposition, sometimes violent opposition, for instance, to the cartoons. Are you concerned that what you're doing is catering or caving, and in essence caving to the heckler's veto?
I'm more interested in Judd's thoughts, but as for mine, you're absolutely right that the Supreme Court never has very satisfactorily reconciled the opposition to the heckler's veto with the entire fighting words doctrine, which was supposed to be a narrow exception to free speech, which said that you could only ban speech that were likely to cause a reasonable man to fight, which comes from the Chaplinsky case. So the cop who was insulted on the street was able to ban the speech because a reasonable person would respond with fisticuffs to the insult. Well, that works as a narrow exception in a culture where people don't take very strong offense, and when there are very few words that would cause people to fight, and basically where sensibilities are hardy. But as you suggest, now that a blaspheming video can cause the world to erupt in riots, the category of what's fighting words or what's likely to incite violence becomes much greater, and certainly there is a danger of a heckler's veto. So the Supreme Court hasn't reconciled this, but Judd, now it's up to you. How are you going to solve this problem?
Well, I'm not going to claim to have solved it, but I actually don't feel like we're caving, and I think this is a perfect example. I mean, the pressure and the request, both internally within Facebook and people who are concerned about it, because we're a diverse bunch of people who are very vocal and have serious opinions, not just within my group, but obviously, engineers coming and sitting at my desk and saying, why is that up, or why you take it down? The standard that we've set is basically that you're not allowed to organize or promote that violence, but that the fact that a piece of content, whatever that content may be, is likely to result in bad behavior by the people who are reacting negatively to that is not reason enough for us to take that down. And it's a hard thing. I mentioned earlier about how every once in a while there's just one of those things that makes it very, very obvious that this has real world consequences to real people. And those types of situations are the ones that get me and the rest of the people on the team.
But some companies take a different view.
Yeah, they do.
Network Solutions refused to host Geert Wilders, who Peter mentioned is the Dutch parliamentarian who's a virulent anti-Muslim. He produced a film and they refused to host it. They said, we don't want our service used for stuff like this.
Right, and that's why, I mentioned this before, and we go back to this over and over and over again. Facebook is a very mission-driven company. making the world more open and connected is on the lips of everybody who walks through that door every single day, and it sounds like I'm telling you that because I'm a cheerleader for the company. The reality is that is something that we go back to as the bedrock of the philosophy for our policies, at least, literally every single day.
Peter.
If my concern is the other part of this issue, incitement to violence, that it seems to me that it's the right thing that you don't give in to pressure by those who would say that I'm so offended, I act violently if you don't take it down. But it seems to me that in order to avoid that, perhaps you could, so at the same time you could save the way to restrict speech in such context, not necessarily calling for action. Other speech without calling for action in certain context also can create imminent danger of violence. So speech that incites violence by those who already have prejudices against the group, which is the target of the speech. So I'm saying that what about making a distinction between danger of violence by those who are not incited to act violently, but claim to be so offended that they would act violently, and incitement of those whom the speech is going to incite against the target group. So if there is neo-Nazi speech that is inciting neo-Nazis and other extreme right-wing people to stop the LGBTQ parade, for example, or threaten and also perhaps physically attack Roma Hungarians in their homes, that seems to be a different story, because then the person who's speaking is going to incite through mobile devices through which people can access the internet in a very instrumental way, somewhat similar, I think, how the infamous radio station worked in Rwanda, people who think similarly to the speaker. It's saying that, comrades, go out there and hate that group and perhaps also attack that group.
But that's classic incitement, rather than people saying, I'm so offended I'm going to engage in violence.
Right, and that's the line that we draw. So at that point, when you're organizing or promoting or inciting in that way, we actually do take that down, and that is what is prohibited by our policies. So, but it's still subject to a credibility standard. And that's where, again, and I've said before, these are imperfect standards. We're always trying to improve them, but the getting to the point that it's beyond which this is actually likely to result, or we believe that someone is actually promoting that violence, and the line there, and determining that line is the one that we're trying to draw.
Let's turn to the audience again and see if there are other questions. Marvin, I don't mean to usurp your job as moderator here.
You've mentioned both how you have a very diverse group at Facebook, and also how you try to have these very objective standards. But I'm wondering if you make an effort to make sure these various teams each has a bit of diversity on it. I'm thinking, for example, that no matter how objective a standard might be about pornography and what pictures should be taken down, a female and a male might look at it very differently. So how do you handle that sort of issue?
Yeah, that's a great question, and I'll give you an example. We have, as I had mentioned before, we have operations teams in 4 offices on 3 continents, and as silly as it sounds, and you actually alluded to it, but most people think it's really silly to say that it's a hard decision, or it's a hard thing to define nudity. And nudity is prohibited by our terms right now. So this was before I had started, but it was in the era of we had a list of rules and no real framework as to why those rules existed. And we had just opened our office in Hyderabad, India. And there was a prohibition against nudity and sexual conduct. That it's different than, the standard is different than it is today, but that's what it was then. And they were struggling with defining those objective standards among everybody. And so at some point once you got past all of the if then, and you still got through, the last thing, the instructions were, well, if it just seems too sexual, people can make a call. And the result of that was, because of the cultural sensitivities of those in the Hyderabad office in India, that we were removing photos of people kissing. And so because their interpretation of too sexual was literally a mouth-to-mouth kiss. So again, that was a few years ago. We've done a much better job of making those standards objective, but to some extent, we will never get rid of that. There will always be something there. What we're trying to do is provide instructions to people that prevent them from jumping kind of out of their job as a reviewer of this content and into their personal beliefs. We get there. We try hard to have all of Facebook represent the diversity of the rest of the community that we serve, which is obviously global, and we try very hard to make sure that these individual teams are diverse, but we don't spend a whole lot of time making sure that, for example, the team that's reviewing nudity has a broad array. We're trying to hire the smartest, the best people that are likely to be good at that job, and then others that they end up going to at Facebook.
Chris. We're right at 5 o'clock, and I promised that we would end promptly. This has been a most interesting program this afternoon. I want to thank all of our panelists, and I hope that the audience will join me in thanking them now. I'd also like to thank the people who really made the program responsible. There's a front office here, and that's who you see on the platform, but the back office consists of the staff of the Anti-Defamation League and the University of Houston Law Center. And except for those people who really spent the time putting the program together and organizing it, we wouldn't be here this afternoon. So please join me in thanking them as well. Last but not least, thank you for being here this afternoon and supporting our attempt to bring continuing education programs like this to the University of Houston Law Center. There is a reception that will follow in the Frankel Room, and each of you is invited to attend, and I hope that you will. Thank you again for being here with us today.